This is very nice compared to previous sessions. As Michelle mentioned, we are going to be taking questions through the questions panel in your dashboard. We've been asked to hold questions, the majority of the questions, till the end. If there's a clarification question in the middle, I will try to catch that and interrupt the presentation. But otherwise, please put your questions in as you come up with them, and then we will address them at the end. So with that, thank you very much, Ray, for offering to do this, and take it away.
Great. Thanks so much. Good afternoon, everybody. I know it's a busy time of year, but nothing turns people out like an ethics CLE. I know it's you're a captive audience for this, so I appreciate you logging in. So we're going to talk about ethics in foreclosure litigation, but I think that many of the issues that we'll discuss you'll see that they're probably applicable to many different areas of your practice. They are the ethics rules that we'll discuss are trans-substantive. They go across different substantive areas of law. They don't just address foreclosure litigation. And I think that they are applicable to many different legal services contexts. So I hope that even if you do not practice in this area, that you find this helpful and informative. So we're going to talk about a couple of issues. Let me get this going. There we go. We're going to talk about a couple of issues today, four to be precise. If there are more issues that you're facing, I'll try to address them if you would like in the questions, or maybe this can give maybe your questions in other areas or other types of questions that you're facing in your practice could be the subject of another ethics CLE in the future. Also at the end, I'll give you contact information for me. I'm more than happy to talk to you in the future more, to drill down on some of these issues, but also if you're facing, particular issues that particular fact patterns that maybe we don't address squarely here. Many ethical issues can be, are common, but there also are unique issues that come up as well. And I'm happy to speak to you individually offline as other issues may come up, or as I said, to drill down on specifics if something we talk about here touches upon things that you face but would like to elaborate more with them. At the end, I'll give you my contact information, and you should feel free to contact me either by email or via phone. Just by way of background, I spent about 14 years in legal services at the Legal Aid Society of New York, and then at the Urban Justice Center with a brief stint at New Haven Legal Assistance. Most of my practice was in housing, but in landlord-tenant. But since joining the Academy about 7 years ago, I've tried to focus a lot of my scholarship on access to justice issues and the foreclosure crisis, and have married my interest in legal ethics with my interest in legal services practice. And in the foreclosure context, as you all know, it is a veritable ethical minefield. And so we'll talk about just 4 issues today, but I know that there are many more that each of you grapple with probably on a daily basis. Today, though, we're going to talk about 4 issues. First, the no contact rule. Second, communication regarding the consequences of settlement. Third, the advocate witness rule. And fourth, the duty to continue representation to the conclusion of the matter. As I said, I know that there are other issues that folks face, providing, what you can give, to what extent can you share ghost written material with lay advocates. Where is the line for, for example, for housing counselors for the provision of legal services, the unauthorized practice of law. Those are all issues that I know that many of you face, but we're going to talk about these four in particular. If there are other issues, again, that you'd like to bring up, we can bring them up in the questions portion, or you can talk to me offline. So first up, the no contact rule, dealing with, the no contact rule is communication with represented parties. For this issue, we turn to Rule 4.2 of New York's ethics rules, and that's the no contact rule, subpart A, that provides, in representing a client, a lawyer shall not communicate about the subject of the representation with a party the lawyer knows to be represented by another lawyer in the matter unless the lawyer has the consent of the other lawyer or is authorized by law to do so. So that in and of itself, the rule is quite dense for a rule of professional responsibility, professional conduct. So let's tease it apart. B, notwithstanding the prohibitions, unless otherwise prohibited by law, a lawyer may cause a client to communicate with a represented person and may counsel the client with respect to those communications, provided the lawyer gives reasonable advance notice to the represented person's counsel that such communications will be taking place. So, so those are the two main components of the rule, but perhaps it raises more questions than it answers. And so there are a number of different components to the rule. And the first is the individual represented in this matter? Let me see if I don't know if you're seeing this. Let me see if I can close this out. Yeah, there we go. No, it goes on the other side. Maybe that does it. Is the individual represented? So that's a key question, and i.e., is the other party represented? So the question here is, does the lawyer know whether the other party is represented? And so this is a situation that lawyers may find themselves in. A representative, perhaps of a servicer, appears, in the court case, or in the courtroom, or the servicer contacts the lawyer to get some, try and get some information from the lawyer, or the lawyer wants to contact the servicer to get a breakdown of the mortgage payments, the alleged debt. And so the question first comes is that servicer or some other representative with whom the lawyer is dealing itself, him or herself, represented in the matter. And so, pretty much you can assume that with a corporate client, their opponent, that corporate opponent is going to be represented, and you should always inquire whether or not the servicer or some other party is in fact represented. There's some case law on this issue for corporate parties, but we'll get into that in a moment. You shouldn't just act under the assumption that a party is contacting you. You can assume they're not represented. I would say the burden is really on the lawyer to assume that the party is represented, and at a minimum should ask the question. If you've dealt with the servicer in the past and you know that they are represented, they've been represented in the past, you should definitely assume they're represented and act under that assumption, and thus not communicate with that party without the consent of its lawyer. Now, the line is not always so clear when dealing with a corporate party, whether the corporate party is covered by, that individual representing the corporate party is covered by the no contact rule. So we've got a pretty influential case law in the state of New York that's actually followed in other jurisdictions, the NYSEG case out of the Court of Appeals, and it uses the language, can the individual bind the corporation with his or her admissions? So that is a fairly loose and I would say broad standard. And for example, if you're asking a servicer, send me a breakdown of the mortgage debt that's outstanding, would you want to use that if you got a breakdown that you thought was favorable? Would you want to use that as an admission of the servicer, binding on the servicer? Again, I think the answer would be yes. And if that is the case, then the party you're talking to, that individual, is covered by the no contact rule. So not every corporate representative is covered by the term client for the purposes of the no contact rule, but the NYSEG case does set the standard that an individual who can bind the corporation with his or her admissions is covered by that no contact rule. Okay, so all is not lost if you conclude that the party with whom you'd like to communicate is covered by the no contact rule, because you can seek the permission of the opposing attorney to speak to that individual. Now, may the opposing attorney give you the permission? Maybe not. But certainly you can, the rule does contemplate you seeking that permission. Now, who can give the permission? It is essential that the lawyer is the only one who can give the permission. And if we go back, we look at the language of the rule, be represented unless the lawyer has the consent of the other lawyer. So that's essential. There are many instances in the rule where an opposing party can give consent. For example, consent to a conflict. Here, only the lawyer can give the permission. And obviously, when you're dealing with a conflict of interest and the other party is represented by counsel, it's the party who can give the consent to the waiver of conflicts, but you can't get it unless you operate through the lawyer because of the no contact rule. But the bottom line is, this is one of the few instances in the rules where it's the lawyer who gives the permission, not the client, not the opposing client. I've been approached in my practice. I've been approached by opposing parties many times, and they would say, oh, Ray, can I talk to you about the case? You think we can settle this case? And I'd say, look, I can't speak to you without the permission of your lawyer. And the party would say, oh, no, don't worry, I'll give you the permission. You can speak to me. It's like, no, it's only the lawyer who can give the permission. If you want to speak to an opposing party, you need to get the permission of the lawyer. I would suggest you get that permission in writing if you're going to pursue it. An email is sufficient. Certainly an oral okay is also sufficient. The rule does not say it needs to be in writing, but I would urge you to get it in writing if at all possible. Again, it's the lawyer who gives the permission. Now, other exceptions to the rule, right? So getting permission certainly exempts you from the rule, but also is the person with whom you'd like to have contact a former employee of the party, and if so, the rule does not apply. Now, case law has developed. Again, it's the NYSEG case. You can read the NYSEG case and further case law after NYSEG says that you can speak to former employees of a represented party, with one exception to the exception, which is you cannot probe communications that would otherwise have been privileged. So you're speaking to a former employee, absolutely fair game, with the exception that you cannot speak to that former employee and ask him or her, well, tell me the advice the lawyer gave the corporation. Tell me what the lawyer said. Tell me what the individual said to the lawyer in order to get legal advice. So if communications would otherwise be privileged, i.e. communications between the lawyer and the client for the purpose of obtaining legal advice, even if that employee with whom you would like to speak is a former employee, you can speak to them about many things, but you cannot speak to them about conversations they had that would otherwise have been privileged communication. Now, even if the one final step, and this is blessed in the NYSEG case, even if you determine one, the lawyer, the party may be, the individual with whom you want to speak may be protected by the attorney-client privilege. You're not sure. You don't think the lawyer would give you the permission. You still can seek. I'll jump around a little bit. Forgive me. You still can seek a court order to speak to a particular individual, i.e., you can get some clarification whether a particular individual working within the corporation is in fact covered by the no contact rule. That's what the NYSEG case gets into. It says a mere witness to an incident is not covered by the no contact rule, gives the lawyer permission to contact that individual without the permission of the client's lawyer. So if you want to seek, if you think a party, an individual that you want to speak to may not be covered by the no contact rule, but you want to be sure, you can always seek out the permission of the court to speak to that individual. Now, do you lose the element of surprise? Of course, but it's better to pursue that than to lose and it be determined later on that you violated the no contact rule. Now, going back one, forgive me, clients can always speak to clients. Clients can speak to clients, but at some point you cannot, you may be sort of using the client to skirt the rules, and Article 8 says, of the ethics rule says, you can't, through the actions of another, get around the rules. And so at some point, if you're counseling your client to go speak to the other side, telling them what to say, what not to say, giving them a script, then 4.2 kicks in again. And as we say, 4.2b, as we talked about before, says that if you're going to counsel the client to speak to the other side without the other lawyer present, you've got to give notice to the other lawyer that you're doing so. So generally speaking, clients can always speak to each other. Your client can always speak to the other client to the extent you're counseling and advising your client, in an in-depth way, more than saying, hey, look, if you want to speak to the other side, you're always welcome to do so. If you're going to go in-depth and give them, some guidance, what to say, what not to say, you've got to give heads up to the other side's lawyer that you are doing so. And again, that's what B says, giving reasonable advance notice to the counsel that such communications will be taking place. Okay, so that's the no contact rule. Let's move on to the second issue. communication with respect to the consequences of settlement. I know that we're coming up to the point where the tax relief for homeowners getting principal reduction benefits is coming to an end, and so that's something that if the Congress doesn't step in, that's something that you're going to have to talk about. So here's the rule. Communication with a lawyer shall promptly inform the client in terms of, you can see the rule, things requiring informed consent, material developments in the matter, including settlement or plea offers, any information required by court order to be communicated to the client, should 2, reasonably consult with the client, including settlement or plea offers, consult with the client about the means by which the client's objectives are to be accomplished, keep the client reasonably informed about the status of the matter, and consult with the client about any relevant limitations on the lawyer's work. So again, forgive me, I jumped around a little bit, but just to go back, there we go, including settlement or plea offers, and I do think consulting with them, with your clients, about the consequences of settlement, including what impact settlement might have on the credit ratings or the tax implications of settlement is important. Now, if you don't feel competent to advise them on what the impact of the tax consequences are, it's completely sufficient for you to say to the client, and I would suggest doing this in writing, that they consult with a tax professional about the consequences, and simply writing them a letter saying, here are the contours of the settlement offer being placed on the table, and there may be tax consequences of this, specifically the principal reduction that you're obtaining. I strongly urge you to consult with a tax professional about those consequences, because you're not in a position to advise the client about those consequences. I think that's sufficient. But if you don't, if you don't make the referral and either give bad advice or neglect to advise them about those consequences, I think it's fair to say that a lawyer could face some degree of malpractice. We've seen this in the criminal context, where lawyers advise a client to accept a plea without advising them of the potential immigration consequences of accepting those pleas, i.e. that they might get deported. We've seen case law now developing that that's ineffective assistance of counsel, and also when you've got ineffective assistance of counsel, you have the specter of malpractice. So although I can't say I've seen cases where in the foreclosure context someone has been sued for malpractice for not advising them of the consequences of settlement, for example, of the tax consequences, as we've said, I do think that it is a possibility, so it's something to be aware of. And I do think even advising your client of, in terms of making a referral to a tax professional, I think that's sufficient to discharge to under Rule 1.4. Okay, moving on to to the Advocate Witness Rule 3.7, excuse me. A lawyer shall not act as an advocate before a tribunal in the matter in which the lawyer is likely to be a witness on a significant issue of fact, unless the testimony relates solely to an uncontested issue. Testimony relates solely to the nature and value of legal services rendered. Disqualification would work as substantial hardship. Testimony relates solely to a matter of formality. Testimony is authorized by the tribunal. A lawyer may not act as advocate before a tribunal in a matter if another lawyer in the lawyer's firm is likely to be called as a witness other than on behalf of the client. It's apparent that the testimony may be prejudicial to the client, or the lawyer is precluded from doing so by Rule 1.7 or 1.9, i.e. there may be a conflict. So that's in a malpractice, like in a malpractice context. So why, this is important to you, as I understand in the question about the lawyer becoming a witness comes up in the context of the settlement conferences, and sometimes an issue will come up: what was promised by a servicer, or the attorney alone is a witness to abusive behavior, or the witness, the lawyer is witness to malfeasance or a misstatement or a failure to bargain in good faith, and the lawyer moves for some sanctions or to dismiss the case based on that, the actions of a servicer or a lawyer. And the question has become, question has arisen: can the lawyer serve as a witness in the case, i.e., a witness to the misstatements or the misconduct of the opposing side? So there is some case law. Here is the leading case on this, which is not great: Falk against Gallo. The advocate witness rules contained in the code, which have been superseded by the rules of professional conduct, provide guidance but are not binding authority for the courts in determining whether a party's attorney shall be disqualified during litigation. Here, since the plaintiff's attorney was the only person other than the parties who had knowledge of any discussions regarding the terms of the oral agreement underlying this litigation, he is likely to be a witness on a significant issue of fact. Accordingly, the Supreme Court properly granted the defendant's motion to disqualify the plaintiff's attorney. So there it was, obviously you can see from the quote, an oral contract. There's testimony about the oral contract, and the lawyer was a witness to the oral agreement, and the court said that the lawyer could not be, could not give testimony in the case and also be, lawyer representing a party. So they're not great case law, but there's some other case law out there I want to point you to as well. So one case, the Ramey case, that said that the advocate witness rule is much more important in the context of a jury trial. Many of these motions where the lawyer may want to give testimony, the lawyer is not going to be in front of a jury. So that's one argument you can make. Then the next question would be: can a legal services office still represent the party, the homeowner, while a lawyer in the legal service organization serve as a witness? And there the case law is actually okay. The firm, and of course the legal service office qualifies as a firm under the definition of what a firm is. The firm there in Owen and Mandolfo, the court said that the firm can continue representation, so another lawyer in the legal services office could continue the representation, but just the lawyer serving as a witness couldn't be the lawyer on the case any longer. Adams against Swazi is another case in federal court that says the same, but People against Papa is an older case that goes the other way. People against Papa is a good case, but Colosino goes the other way. So it's just something to be aware of. Finally, I want to leave time for your questions. The last question I wanted to address is the question about duty continued representation. I understand, in your practice sometimes cases languish, and you realize, that it's essentially a no defense case anymore. The client really doesn't have much possible future ability to pay. You're not quite sure why you're being burdened with the case anymore. And it's not really along the lines of your office's mission to continue the representation. Unfortunately, you do have a continuing duty to continue representation. I know that many of you, take that obligation to heart, and case law certainly endorses that position. When an attorney is retained to conduct a legal proceeding, he enters into, and obviously she enters into, an entire contract to conduct the proceeding to a conclusion and may not abandon the relation without reasonable or justifiable cause. That is certainly enshrined in what we do, and I know you all take it to heart. If you do wish to withdraw, you turn to 116 for the basis for withdrawal. And they are laid out there, obviously, in all of your contexts, in these contexts where you're appearing in a case, formally appearing in litigation. You have to get the consent to withdraw from the tribunal, but then there are some grounds upon, the grounds upon which you may withdraw are set forth in 116. The first set, a lawyer shall withdraw. That representation will result in violation of the rules or of law, physical mental condition materially impairs the lawyer's liability. I'm not going to touch that one because you may say that a client drives you crazy. I certainly said that about some of my clients in the past. The lawyer is discharged, i.e. the client discharged the lawyer. The lawyer knows that the action is being taken merely for the purpose of harassing or maliciously injuring another person. Now, even under B, however, where the law says, the rules say you shall withdraw, you still have to get permission of the tribunal. Now, you can seek to withdraw, and C lets out or lays out the grounds where you can seek to withdraw. Again, you still need permission of the tribunal. Withdrawal can be accomplished without material adverse effect on the interests of the client. Client persists in a course of action involving the lawyer's service. The lawyer reasonably believes is criminal or fraudulent. Client has used the lawyer's services to perpetrate a crime or fraud. Client insists upon taking action with which the lawyer has a fundamental disagreement, and this is a serious disagreement, not just a minor disagreement. Client deliberately disregards an agreement or obligation to the lawyer as to expenses or fees. Client insists upon presenting a claim or defense that has no basis in law. Client fails to cooperate. The lawyer's mental or physical condition, again, client knowingly freely assents to termination of the employment. The lawyer believes in good, and you can see what 8 and 11 say, but I didn't think it was really relevant to our conversation. The lawyer reasonably believes in good faith that the tribunal will find the existence of other good cause for withdrawal, or client insists the lawyer pursue a course of conduct which is illegal or prohibited under these rules. Now again, D requires the permission of the tribunal. Now the question here is, can you what are the obligations to this, to the client, or excuse me, what are the steps you must take? Obviously, you need to proceed by order to show cause to get permission of the tribunal. How much information should you reveal? Normally, in an affirmation in support of your order to show cause, the court, should take as sufficient your statement that, ethical constraints require that you make the motion at this time. Sometimes the court may ask for more. Sometimes the court may, go in camera and ask for you to reveal ex parte what the reasons are, but usually it should be sufficient for you to say, ethical constraints make it, make this motion necessary. So I'm going to stop there, see if I can get you back on, and so I can see what the questions are. Let's see, there we are. Let's see. I'm going to close. No. I can't see. Becky, you there?
Yeah, I'm still here.
Okay,
No
so
problem.
do you have? I don't can't seem to get back to the questions. So maybe you can just make them oral.
Yep, we don't have any questions right now, but actually I have a question.
Sure.
When many folks are taking these cases and having the client sign a retainer agreement indicating limited representation, I know you said at the beginning that might be a topic in and of itself.
Yes.
But perhaps at the time, can you go into that a little bit?
Sure. So the rule on that, I actually have a slide on that, and let me see if I can go back to this. So here's the rule on limited representation. It's 1.2, doesn't say much. May limit the scope of the representation. The limitation is reasonable under the circumstances. The client gives informed consent, and where necessary is provided, notice is provided to the tribunal and or opposing counsel. I think the idea of agreeing to represent a client, and tell me if this is what you're talking about, Becky, the context where you agree to handle the case through the mediation phase, I think that's completely reasonable. And so, as long as the the client gives informed consent. So I think other than, give me another example where you've got a limited representation agreement.
Well, that's pretty much it. I mean,
that's it. I think that's completely reasonable. We certainly see this in other contexts. As long as it's explained to the client understands, and I think it's helpful to give notice to the tribunal and opposing counsel that you're only representing the client through the mediation phase. You can always say that at this point we have agreed only to represent the client through the mediation phase. We have not made a determination yet as to whether we will represent him or her if the matter is not resolved. That may, limit the, any gamesmanship, but I think it's that, in terms of the other side, getting through mediation unsuccessfully, knowing that, the homeowner is going to lose representation at the conclusion of the mediation. So that's how I would approach it. I would say, at this stage, we've not made a determination yet as to whether we will handle the case after mediation. But I think that, as long as you follow 1.2, give notice to the client, it's reasonable in scope, and certainly saying you're agreeing to represent the client through the mediation phase only, I think that's totally fine.
I'm just sort of asking some questions now, but is there a way that, let's say you have ended the settlement conference process, let's say you were perhaps vague in your retainer agreement, and you didn't specify that it was just for the settlement conference, or it was, if you just said, I'll represent you in your foreclosure, let's say, right? And the homeowner you've gotten your order of reference, they have no claims, you've not filed an answer, they've acknowledged they're just going to give up the house and ride it out. If you sought permission from the client and then alerted the court, is that sufficient to withdraw representation?
If the client consents, it should be sufficient. But you're still going to need permission from the court.
Okay.
The client doesn't, and the court doesn't have to accept it. Even if the client says that they consent, They're letting you with, they don't have no objection to you withdrawing. You still would have to proceed by order to show cause, and the court may not let you out of it. So I think it's, once you've appeared, and the mediation would absolutely, unless it's, informal mediation not involving the court, you have to appear. And so, in for a dime, in for a dollar. You're appearing on the case, and you don't specify that you're only that your appearance is limited, then the court is going to say, you appeared, counsel. You're in this case, and you need my permission to withdraw. Now, most courts, if they've got the consent of the client and the lawyer's looking to withdraw, they'll grant that consent, but they're not obligated to. So if to the extent that you enter on the record that your appearance is limited in scope, only to the extent that only agree to represent the client to through the conclusion of the mediation phase, that's the safest way. Is to specify in the appearance, and that would qualify as giving the court notice, and the other side, obviously.
Right.
Now, again, if you don't have that, if you're not specific in the retainer, but you do appear, that does trigger the order to show cause requirement and the permission of the court to let you out of the case. And just gosh, this case was bigger than we thought when we appeared. That's not going to fly.
Right. Okay. I don't see any other questions right now, Ray.
Okay. Well, let me go. I'll go to my last slide if I can get to it. There you go. There's my contact information. If you have any follow-up questions, feel free to reach out to me. I appreciate you taking the time to get this CLE with all that I'm sure you've got going on before the holidays. So thank you very much.
Okay, thank you. And I would just like to give a quick piece of information to folks on the call. Because we did not go the full 50 minutes, unfortunately, we have to provide a 0.5 CLE.
Oh, well, let's do another question. Becky, think of another question.
Okay. Thanks for putting me on the spot. Let's see.
All right, here's another one. So this is something that's come up in other contexts. Unauthorized practice of law. What's the line? Can you give advice to a housing counselor? To advocate on behalf of a homeowner? Can you work with a community organizer? It's very tricky. Can you give an individual homeowner advice to advocate for him or herself? Absolutely. You have to be careful about the advice you give. A lawyer-client relationship can be formed in the sense that if you give bad advice and that advice is followed and the individual is harmed, there can be some malpractice liability. So be very careful about the type of advice you give. I think giving standard advice, pointing them to pro se manuals. I know Empire Justice has a wonderful pro se manual on the foreclosure process. Pointing people to that type of material, pointing people to court advocates, provided by the courts, telling them to speak to court attorneys, speak to the mediators, telling them where the courthouse is, telling them, based on the information they give you, how much time they have to respond. That sort of information is fine. You want to be careful about giving advice to clients or to pro se litigants for fear that it might create an attorney-client relationship. Now, in terms of the housing counselors and a community organizer, for example, it's much better for you, if you're going to do some community education, to go out and do it yourself rather than giving advice to a community organizer or a housing counselor that is, again, beyond the stock advice, like, well, here's a pro se manual, here's some information you can have, here's some basic defenses to put in, because you can assist others. It's not just the lawyer. A lawyer can assist others in the unauthorized practice of law. And the definition of unauthorized practice of law is broad, and basically it is the provision of services in New York State, the provision of services that require the expertise of a lawyer. So you think about some of the things that we know housing counselors do. Think about things that we know housing organizers do. Just be careful not to be assisting in that type of work. The other thing to think about when talking with housing counselors is the extent to which, if you're working with a housing counselor and a client, so you're formally representing a client and you're working with his or her housing counselor, that those communications are not necessarily privileged. So we could do another session on that issue, but it is important that if you're talking, the housing counselor's presence should be limited, and you shouldn't necessarily discuss settlement positions with the housing counselor present unless it's really necessary to facilitate the representation, that the housing counselor is on the line. They may have reviewed some documents. They may know things that your client doesn't know. Then it's okay, and that's the line to draw. Are they facilitating the representation, or are they not? And if they are not, then their presence can work to breach the attorney-client confidentiality, to breach the privilege. And the opposing side could ask your client what was said in those conversations. So you want to be careful about when you're communicating with a third party, like a housing counselor, about things that would otherwise be privileged. Okay. Again, I can do another session on that. People can ask me offline about that. Becky, did we get our full hour in?
Great, thank you very much. We got our full hour in, yes. So disregard
Excellent.
my previous, and good job, Ray. And I would be very interested, folks, actually, today we'll be sending out a survey for possible training topics for the 2014 training year. And if you are interested in any of the suggestions or anything else that you come up with that maybe Ray suggested or something else, I'm very interested to hear from you about what you're interested in hearing about next year, both as an in-person training or as a webinar format that we've done for the last year. So, Ray, as always, thank you so much. And
My pleasure.
I hope everybody has a holiday.
Happy holidays,
Thanks.
everybody.
Okay, one last thing. I want to announce the CLE code. I did put it in the chat feature, but in case you didn't have it up on your screen, the code is MDW 8121. It's Mary David William 8121. That's it.
Thanks, Michelle. Thanks, Ray.
Thank you.